Good afternoon. Welcome on in to the Thursday edition of From Day One in the afternoon. Court cases are ready to go, and we're picking up with part 2 of the insane court drama that we had yesterday. If you remember, she was trying to fight in family court. However, the prosecution wanted to quash and seal the records due to the fact that their addresses, names, phone numbers were all over every document she decided to post. At that point, the judge said she would advise and get back to us with an answer. We actually don't even get to go there quite yet, as she has decided to go ahead and do a quote-unquote Kim Blandino. And she's filed paperwork to have that judge thrown off the case. So that is where we start this afternoon, with seeing whether or not that judge gets to remain on the case or anything else. And due to that, we will have a new judge hearing. It's just what's required when somebody is slated to be taken off the case. The same judge cannot hear it. So this is where we will pick up today, this afternoon, in Dominion.
Ms. Leyva, this is, okay, there you are. All right, Ms. Borum, this is Judge Wallace. Can you hear me?
Thank you, Mortimer.
Can't hear you.
Unmute yourself, please.
Is it working now? Yes. All right. And Miss, the name on the screen is Sarah, but that's you, Miss Sarah Leyva?
Yes, sir. Sarah Leyva Pike.
All right. I will call this case hearing at this time. This is cause number 325-575-862-15. In the interest of Joshua R. Leyva and Samuel D. Leyva, minor children, and we are here for a hearing on the amended plaintiff's request for immediate voluntary recusal of Honorable Judith Wells in hearing
Thank you, Mike.
March 31, 2021 to be declared a mistrial. I am Senior District Judge R.H. Wallace, sitting by assignment to hear this matter in the 48th District Court today. These proceedings are being conducted remotely by Zoom and also being streamed on YouTube. The court reporter is taking a record of the proceedings, and that will be the official record of these proceedings. Parties are ordered not to record these proceedings, otherwise the same as if you were in court.
I like this judge, but he is straight from Central Casting for serious old Texas judge.
All right, Ms. Leyva, I have reviewed your amended motion or request for recusal, and also the response that was filed by counsel Nicholas Leyva today, and I'm happy to hear any evidence, testimony, or otherwise that you would like to offer in support of your amended motion to recuse.
Yes, Your Honor. Is it okay if I get started?
Yes.
All right. First of all, I want to state that there was an inaccuracy on Ms. Borum's response. She stated that I was accusing her and Newell of rape and molestation of a child. Sir, that is inaccurate. They are actually named defendants in relation to that. However, they themselves are, as in committing perjury, suppression of evidence, however, not specifically doing harm to the child physically themselves.
That just shows a complete lack of experience in this area. If you file a bunch of pleadings, they speak for themselves. You don't have to interrupt at the beginning and say, I'm going to verbally tell you what I freaking wrote out for you. You assume that the judge, to the extent he cares, saw it.
I also noticed that she never actually stated that anything I said was false. In every single one of her points, she unspecific facts. So, Your Honor, I wish to present the very specific facts of what has been occurring actually for the last 2 to 3 years. On May of 2015, Nicholas Leyva and I signed a irrevocable mediated settlement with the assistance of a court mediator on January 29th, 2016. We then had it signed by a judge and affirmed. In August of 2018, Lindsay Newell filed 2 violations for enforcement where she committed third-degree perjury. In these violations, neither one was a violation of our irrevocable mediated settlement, and she went so far as to reword in her filings part of the mediated settlement, intentionally committing fraud upon the courts. Additionally, the affidavit that Nicholas Leyva filed with the petition to amend child custody, again with violations that were third-degree perjury and were not true, his affidavit was not signed. However, it was stamped. When I did a little research, the notary is his friend on social media, and I'm not sure if she could...
Oh, here we go. The focus on the notary. The notary is just not that relevant. And her big gotcha, her big aha, Perry Mason gotcha moment is that this guy apparently is connected on social media. I mean, if that's the standard, I don't know. I guess I have a conflict with every one of you.
Colluded with him, or if he simply just stole her stamp when he was at her house and stamped it for himself. I do not have evidence of that. However, it is very clear that that page is not signed by a notary.
I don't know if you know Mrs. Borum or not. Please don't interrupt these hearings on one person talk.
So this led to a jurisdiction hearing, which was made again.
Ms. Borum, I've muted you. Let me interrupt you a second. All right, go ahead and unmute.
Okay, can you hear me, Your Honor?
Yeah, not Ms. Borum, Ms. Leyva.
Thank you, Your Honor.
The purpose of the hearing is to determine whether or not there are grounds for recusal of Judge Wells for any of the reasons set forth in Rule 18B of the Texas Rules of Civil Procedure. We are not here to hear arguments about what previous merits of the case or anything. It's your opportunity to present grounds to the court for recusing Judge Wells, and that's what I would like to.
So, Your Honor, you have interest in also helping in hiding the original fraud that was committed against myself and my children. There are many laws stating that anything that happens with fraud has no statute of limitations, number one, and any judgment procured with fraud is void. And Ms. Borum is attempting to steal records to hide extrinsic and intrinsic fraud.
That's great. She's reading some bright line rules from law books. 2 points. However, they're not applicable, and you haven't shown fraud. You've been in court a bunch, and you have not established this. So you just assume, a bunch of things, and then make your argument based on that. It doesn't work.
On a void order. And so it all pertains to Ms. Wells, because Ms. Wells, in that hearing, and which I will get to in just a moment, of how she specifically acted outside her judicial capacity and why she should be recused immediately. However, a recusal is not necessary because the order is void, and simply someone just needs to uphold the law in regards to our irrevocable mediated settlements. Because everything that has occurred since our irrevocable mediated settlement is fraud. Not only is it fraud, due to the physical force in which my children were removed by police under a fraudulent order, which stated that I removed them, that I kidnapped them from the state of Texas despite an irrevocable mediated settlement. It also falls under US 15 for sex trafficking of children, or through...
I'm guessing, I have no idea. I don't know the underlying facts here. And by the way, I can believe that the state can get out of hand. I have a video on my channel where CPS and the judge hammers them for it. In Texas is completely out of hand. I'm sympathetic to that idea, but based upon her demeanor and the way she acts and the fact that she continuously loses, I'm not believing her.
Force, fraud, and collusion, which I was going to get to, Your Honor. And I do apologize. I'm sure you have not had the time to review the records yourself and are unaware that these things have been occurring. However, I'm almost to the point of Judith Wells and why she should be recused.
That cannot be a smart move to go and blame the judge, saying the judge doesn't know because the judge hasn't gone ahead and done his due diligence before hearing this case. Just me, Mike. That sounds like a loser.
Giving you the background and the full story of what has occurred and why Ms. Borum responded to all allegations with unspecific facts.
Well,
And did not provide any direct, argument as to what I was saying is untrue.
what I would like for you to address are the grounds set forth in Rule 18B of the Texas Rules for Civil Procedure.
Your Honor, that is not just the only thing, but in regards to civil procedure, she completely ignored.
Yeah. Interrupt the judge when he's when he's
another non-winning
Good
trick.
luck with that.
Her due process of filings. She has received 3 requests to vacate due to intrinsic and extrinsic fraud. During the hearing to seal records, when I brought these allegations to Judith Wells' attention, Ms. Catherine Borum responded the fraud occurred before the final order. She herself admitted that fraud was occurring. In addition, I have not seen my children since they were kidnapped, nor heard their voice in over a year. This is intentional contract interference of an irrevocable mediated settlement, intentional parental rights violations, perjury under TPC 3702 and 03 of aggravated felony level 3rd degree, extreme parental alienation, and intentional conflict, intentional infliction of emotional distress, and RICO collaboration between Nicholas Leyva, Lindsay Knoll, Catherine Borum, and Leyva.
Did she really try to go for a RICO statute there?
Miss Leyva, please slow down. I'm trying to make a record.
Apologize, Your Honor. As you can understand, I apologize. This is very emotional for me. As I said, I've not even heard my children's voices in over a year due to the intentional parental alienation and continual abuse of Nicholas Leyva. Awful.
That is, and she is rude, and I think probably wrong as a matter of law, although I would not give a final thought on that. But what she's got before him is a motion to get the judge kicked off her case. And, so she does some sympathetic things. I feel bad that she hasn't seen her children, but I just highly suspect it's the product of her actions, and they're on display here.
In addition, Judith Wells not only ignored Borum's admittance of perjury in the procurement of the final order.
Well, wait till the end. I agree. She's got an odd affect here, and then she has this weird thing when she's at the end. She's laughing when she should be crying. I think she's trying to cry and can't. It's odd, and it is reminiscent of Amber.
She then cut the hearing to silence me.
And for those wondering, when he refers to Amber, he's referring to Amber Heard of the Johnny Depp Amber Heard trial that just happened not too long before this, in case you're watching in the future.
And sent an order stating that even if my records weren't officially sealed, she would be receiving a list from Ms. Borum about which records did need to be sealed, if not all, when the only issue is addresses, which can easily be redacted and are the job of the court, the district clerk, which I happily agree to. Any addresses, I do not want any harm to come to any parties involved. I would happily remove their addresses. However, Ms. Borum was particularly interested in my affidavit to vacate due to intrinsic and extrinsic fraud, and has yet to actually state how anything is a falsehood. There was also a violation of due process, as I said, according to filings. That's Johnson versus Zervis. There's a whole list. I'm sure you don't want me to go through them. Also,
yes,
where there's no justifiable issue is presented to the court through proper pleadings. Ms. Borum did not provide any proper pleadings in regards to stealing the record. She simply stated she wanted to do it in the best interest of her client. There was
She provided pleadings and argued it in the last video. I got the basis completely from watching that video.
Absolutely no danger to the public in any way, shape, or form, and the only people that gain from sealing my records are Miss Lindsay Newell, who committed third-degree perjury, and Nicholas Leyva, as well as Judge Patricia Bennett. Your Honor, you know exactly what's happening. And Ms. Borum knows exactly what's happening. In the hearing with David Evans, he even asked her to be a witness to state that what I was saying was untrue, and she refused.
It's
Ms. Borum.
Yes, I'm sorry.
Thanks, Jennifer.
Who are you saying David Evans asked to testify?
He asked Ms. Borum at the last hearing to testify and asked her if what I was saying was untrue, and she said, I do not wish to be a witness. So she herself knows that these crimes have occurred against myself, my children, the public. This is treason. This is absolute treason. The laws covering judges.
Capital felony treason. We finally got there.
Yeah, we did, Mike.
She's not also reading the room. When the judge is doing this, letting you cut him off and stuff, it's not because he's weak. It's a complete lack of respect for your position. If I was doing this to a judge and getting into it with them, they would get hot and nasty fast because I actually know what I'm doing and I pose a threat. This is someone who's just thinking, okay, whatever.
Yeah.
There's another public
She's dumb.
officials
Give her a
are
moment.
found at 5 USC 3331 28 USC 543. I'm sure you know where they are. And if a judge has not complied with all those provisions, he's not a judge but a trespasser upon the court.
It appears you're reading from something.
I am, Your Honor. I have notes because I cannot remember all the laws in my brain, unfortunately. I wish I could.
But please slow down so that the court reporter can take down what you're saying.
I apologize, Your Honor.
T-shirt right there.
Also, as I stated before, the fact that they even have the children to begin with, the final trial, Miss Lindsay Newell flat out lied to the judge and stated I failed my drug test while holding them in her hand. No fault was ever found with me, which breaches my 1st, 4th, 5th, 6th, 7th, 9th, organic, 13th, and 14th Amendment rights under Bill of Rights Articles 1, 2, as well as the 11th Amendment. This crime has been occurring against me and my children for over 3 years, Your Honor. And every judge so far has not only ignored all the evidence, but has...
Has it occurred to you that they've listened to the evidence and ruled against you because you're wrong as a matter of law? Has that possibility occurred to you, ma'am?
Oh my God, what a fucking concept, Mike.
Assisted in protecting Miss Newell. I'm sure my husband is not that important. I'm sure it's about Miss Newell, not about him. And I am not asking for anything to happen to them other than the return of my children and the irrevocable mediated settlement, which is our lawful contract to be upheld by Tarrant County courts. But if that is not a possibility, then as I said, Judith Wells did not follow due process of filings. She was blatantly biased in every way possible and did not present herself as someone operating for the courts, but rather someone who was operating in collusion with Ms. Borum and with Ms. Newell.
I don't know. We just saw a video of that judge. She seemed eminently reasonable to me. But,
Yeah,
you know.
and we had that yesterday on this show.
Is that all you have?
Yes, sir.
All right, Ms. Borum, respond.
Yes, thank you, Your Honor. Can you hear me okay?
Yes, everything she said is bullshit, Your Honor. Thank you. Oh, wait a minute. No, you're not going to do the My Cousin Vinny routine? Okay, you're actually going to give a response more than she deserves, but go ahead.
Yes.
Okay, there was a little feedback on my end. Okay, I think that's better. Am I coming through?
Yes.
All right, thank you, sir. I would like to briefly respond. I know that
Let me give you the same admonition that I did to Ms. Neva. I'm not interested in hearing about rulings that people disagree with or agree with. My only concern here in this hearing today is whether there is any evidence that they offered to show that there would be grounds for recusal of Judge Wells under Rule 18B of the Texas Rules of Civil Procedure. So please don't rehash any arguments that do not go to those issues. Okay, go ahead.
Yes, sir. I would like to make a brief argument to the court. As you know, I did file a response earlier to Ms. Leiva's filings. First and foremost, as I'm sure the court is certainly aware, that under Rule 18A that addresses the recusal of judges, there are several different grounds that are set forth that must be adhered to in order for a judge to be recused off of a case. First and foremost, the motion must be verified. And I would point out to the court that Ms. Leiva's motion is not verified. Secondly, she must state with detail the facts that are either within her personal knowledge, or if they are for information and belief, they would be facts that would be admissible in court and specifically stated. From reviewing her motion, and without getting into the merits of the case or the previous affidavits or hearings, I would say that it appears that she's arguing under subsection B1 and subsection B2, stating that she believes that Judge Wells' impartiality could potentially be questioned and or that she has a personal bias. These are the issues that she appears to be attempting to address within her motion. I would object to her motion on several grounds. First and foremost, because there aren't any specific facts that are alleged in any of her points which do attempt to go towards being biased or impartial. Secondly, I would point out that Judge Wells is, I believe now, the fourth judge that's been involved with this case. I believe that, and I have only recently come on to represent Mr. Leiva, but to my knowledge, the only hearing that's taken place in front of Judge Wells was the motion to seal records. And Judge Wells did follow the Texas Rules of Civil Procedure, and she ruled on that motion. There were several other motions that had been filed with the court, but not properly set. At that time, Judge Wells did, in fact, personally set those motions. They were, of course, stayed because Ms. Leiva began to file multiple motions for recusal. Within her motion, as it pertains to bias or impartiality, first and foremost, she says that she believes that Judge Wells has personal interest in bias due to her relationship with Lindsay Newell, who is my co-counsel, and she says Christiana Borum, but I assume she's referring to me. She says that Judge Wells did not deny inappropriate relationships with amicus or ad litem attorneys. Your Honor, there is nothing here that specifies why Ms. Leiva believes that there's an improper personal relationship between any of the attorneys in this case and Judge Wells. Further, I will represent to the court, as an officer of the court, that I do not spend time with Judge Wells personally, aside from perhaps being at one or two bar functions where I have seen her. I certainly don't go on vacation with her and have never been invited to do so. So I would object to this particular allegation and the fact that I don't believe that Ms. Leiva has provided the factual basis that's required under Rule 18A of Civil Procedure. Secondly, she seems to have a problem with Lori Robinson. To my knowledge, Lori Robinson has not served as an amicus or an ad litem attorney on this case, and I don't know how she's relevant to these proceedings in any way whatsoever, quite frankly. She goes on to say that the improper personal relationship has to do with the allegations of rape, molestation, child abuse, etc. Again, she here says Christina Bourne, but I believe that she is referring to me. I'm not aware of a federal investigation, and regardless, any allegations of behavior on my part or Ms. Newell's part, I don't believe are relevant to the recusal of Judge Wells in this case. As far as the allegation that Judge Wells unlawfully violated her constitutional rights by asking her to provide an address, I would represent to the court that that was done because I had been completely unable to serve Ms. Leiva with process on an enforcement, and Judge Wells instructed her to give me a location where I could serve her, whether it was her address or not. She, of course, has refused to do so.
This woman spent enough time playing around with the law that she knows that that's nonsense too. An email, yes, you can get the information to somebody, but under the code, you need to mail it to an address. So a lot of times to effectuate service, you need an address, not because you can't get it to them via email, but because the law requires it.
There's an allegation that Judge Wells has engaged in judicial misconduct by blatantly ignoring any and all requests to vacate a final order. Well, that's untrue, because at the motion to seal, which was properly set before Judge Wells, she personally set the additional motions, some of which were rather nonsensical, to be honest, but she set them regardless on a specific date. She set them so they could all be heard on the same day, and Ms. Leyva would have an opportunity to present all of her grievances to the court. Unfortunately, again, the motion to recuse was filed, which stayed those proceedings. As far as my request for sanctions and attorney's fees, I would tell the court that this is the second motion to recuse that Ms. Leyva has filed. It is essentially identical to the first one, save and except that she included a rather large paragraph at the beginning, which ran through facts and procedure and allegations that she's made in this case. To say that Judge Wells has been blatantly biased in every way possible is simply disingenuous. I would argue that Ms. Leyva is simply unhappy with the results of her case. And
boom. That's it in a nutshell. This attorney's doing a fantastic job all the way through, but there she just said it. She's found all sorts of stuff. She's just unhappy that she lost.
Boom, shakalaka.
And that explains everything.
And to say that Judge Wells has been biased or inappropriate, or that she is a trespasser on the court, there's simply no foundation laid out, events made by Ms. Leyva to support this. This is now the second hearing that I've had to defend for the recusal of Judge Wells. Secondly, I believe that a motion was filed recently by Ms. Leyva where she again requests that Judge Wells be recused without any additional facts being included. And so for that reason, I would ask that Ms. Leyva be ordered to pay attorney's fees in this case of $3,500 for the result of me having to defend these multiple motions.
Yes.
Thank you.
She's heating up.
All right. Any other evidence to offer, Ms. Neva?
Yes, sir. I do want to
just watch us. We're nearing the end here, but just watch her affect and the way she does this. I alluded to this earlier, but it is just bizarre, like her facial expressions and the way she sort of ends this thing.
a brief statement in regards to what she just said. Number one, according to 18(1)B, there is very blatant evidence of judicial bias in accordance with that, and there are specific facts, especially in regards to due filings. The hearings were not set. They were set by the courts, and I was offered multiple dates. However, opposing party refused every single date and then set the hearing to seal records. And again, at the core of this is third-degree perjury and child trafficking. You cannot ignore that just because you want to focus on recusal. Actually, it is U.S. 18-4, misprision of felony. Even if I don't specifically put anything in this filing, there is more than enough in my case records, if anyone would care to review them, showing the extent of the perjury, the bias, the misinformation, as well as documents by judges such as Patricia Bennett that had blatant lies on them, like stating the boys were in Texas 6 months before the hearing. Your Honor, this is a very serious issue that I have been dealing with, and this is not because I was trying to recuse her a second time. I put in an amended motion, and I am not a lawyer. I am just a mom fighting to see her children again. And I did not know that amending the recusal would call for a second hearing. I do apologize for that. Also, I have no money. If you look into my case records, I have filed as indigent, and I have not.
Indigent.
That's not the term.
That's indigent.
Thank you.
If you don't know the word, just say you're poor. Okay.
Had any money coming in due to the constant legal abuse, deception, perjury, and legal abuse that I have sustained for over 3 years. years. Your Honor, Judith Wells is not only interested in protecting Newell due to this case. Even if I cannot present the facts, you can look it up yourself. It's Brad Lamb and Grace Washington. There is a federal investigation, and it is into crimes. Even if Wells is not named as a defendant, it all occurred in her courtroom for almost 5 years. By Ms. Borum as the attorney, and by Ms. Newell as the Atticus attorney. Your Honor, I don't know what to say. We all know here they broke the law. We all know that what is happening to myself and my children is a huge violation of the Constitution.
No, we don't know that. We don't know that. You're making that allegation, and you've yet to prove it because there have been no consequences coming forth from it.
Correct.
So just begging the question that doesn't work for you.
Bill of Rights, basic human rights, and I just ask that you offer relief for me and my children.
Spot on, Susan.
And do what you can in your power, and definitely recuse Wells if that's all you're able to do. Thank you.
All right, based on
that's Judge Wells to you.
Yes.
the amended, the evidence and arguments presented and concludes that the motion should be denied. Therefore, the court is going to deny the plaintiff's amended request for immediate voluntary recusal of the Honorable Judith Wells. The court would also note that it appears that a almost identical motion was previously presented to Judge Evans, and that's going to be that motion was denied as well. As far as the,
I mean, what is this right here? She's putting on like she's crying. She's giving like it's actually worse than Amber Heard, and that's saying something. That's a bold statement I've just made.
Yeah, that is, Mike.
But she's trying to like
quite justified.
Sniffle, and then she's got a big grin on her face simultaneously.
Request for sanctions. The court is not going to impose sanctions. While I appreciate the response filed on behalf of Mr. Leyva, I think these so facially insufficient and factually insufficient that it's really not necessary to be expending attorney's fees to oppose those. You're certainly welcome to participate in the hearing.
I agree with the judge here, but you gotta really get into what that ruling was. He's like, this motion sucked so bad that I'm not granting attorney's fees to defend it because it didn't rise to the level of actually having to think about it. So it sort of helps this woman admit he's not granting attorney's fees, but insults her at the same time.
But I'm going to deny the request for sanctions, at least at this point. That'll be the ruling of the court, and I will get an order entered to that effect. Anything else on this motion?
No, Your Honor.
Committing a felony. Just going to say it on public television. Right now, all of you are committing felonies. You have a wonderful day trafficking children.
Public television? This is a court case. How is this public television?
All right, that'll conclude the hearing, and you can leave the meeting.
Thank you.
Mike, you want to wrap this up?
Well, there you have it. The judge did the right thing in terms of denying the motion. I would have hit her with some attorney's fees. I know why he didn't. He didn't because she doesn't have any money and it's pointless, and it'll just create more conspiratorial nonsense, and he doesn't want to do that. But she deserved it for all the world. She did file a frivolous motion. The right thing to do is to assess some attorney's fees to her, because that attorney did have to prepare for this thing. I agree with his thing, is like his ruling in the sense that it's like this motion is so bad. However, the attorney still had to prepare for it. She still has to be there. And she doesn't know that the judge is going to see it that way, so she has to do it as if it's contested. That's a minor point. He gets the big things right, and I agree with him on it. But I would have probably assessed some attorney's fees to her, and I would have held her in contempt for what she said at the end. I would have held her in contempt, plain and simple. After a ruling, you don't sit there and lob bombs about child sex trafficking at a judge. And I think he's a good judge, whatever, and it's certainly within his discretion. So I'm not saying that. I'm just saying if I was sitting on the bench, I'm ringing you up for that. I'm ringing you up for that, and you're going to spend the night in jail, at least. And this is why I'm not a judge. Thank you all for coming out. I really appreciate it. There's some wild stuff coming up here. Law and Lumber is going to be in Chicago this weekend. I think we're going to do a stream on Saturday, and there might be a meetup sometime Saturday in Chicago if anybody's around in the Chicago area. I don't know what'll happen with that.
All right. Thank you, Mike. I'd let you get your little plug-in. Because you're always so nice to us and giving us great content. Figured that time you did deserve yourself a little bit of a plug. Well, that will wrap up part A. Of course, we'll have our auditors, frauditors, subsets, and Karens, and probably with some good Father Skeptic thrown in the evening, and of course, the final portion of the study conversation with Art Bell in the overnight. Until then, like, share, and subscribe. Help us get to that goal of 50,000 views, so those red boxes go out to everybody. And 1,000 subscribers, so Google puts us on the algorithms. And like, share, and subscribe. We kind of want another release to Krakens as we march along this afternoon and every afternoon here from day one. Have a great afternoon. Again, we'll see you tonight for frauditors, auditors, subsets, and Karens as we march through Dominion.